Welcome, everyone. I'm Kathy Albiza. I'm the VP of Institutional and Sectoral Change here at Race Forward. And we are very privileged today to have Darieli Rodriguez from Lawyers Committee for Civil Rights Under Law join us to discuss the legal environment and the challenges that it is posing to advancing racial justice at this moment in time. Darieli, thank you so much for joining us. The work that you and your organization are doing right now is crucial. It's historic. You are playing an extraordinary role. So let's just start by maybe telling us a little bit about yourself and about Lawyers Committee before we delve into what is happening with both our constitutional and legislative frameworks.
Great. Thanks, Kathy, so much for having me here today. The Lawyers Committee for Civil Rights Under Law is a national civil rights organization, and it was started by President John F. Kennedy in 1963. He started the organization as a call to action for private attorneys in law firms to use their resources to tackle systemic racism at the height of the civil rights movement. And it's a mission that continues to be very much alive today, especially in this, as you said, historic pivotal moment that we are currently experiencing. The Lawyers Committee, we fight every single day inside and outside of courts to advance justice for Black communities and communities of color. And we engage in multiple routes of advocacy through policy advocacy, outreach and education, impact litigation. And in my role as Deputy Chief Counsel, I am responsible for overseeing our litigation in 3 units: in fair housing, economic justice, and educational opportunities. In addition to that, I'm also responsible for overseeing our response from the fallout of the SFFA ruling in the Harvard and UNC cases that the Supreme Court issued about a year ago. We're actually about to come up on the 1-year anniversary of that ruling, and we've been doing a lot of work starting from even before the ruling came down to teach folks and educate folks about what the ruling said, what it didn't say, and we're engaging in a lot of advocacy to ensure that entities, including nonprofit organizations, feel empowered to continue their racial equity work in this moment. So really looking forward to talking to you more about the work that we're doing in this moment a year out.
And fallout is almost an understatement, right?
Yeah.
Considering the avalanche that we have had of attacks. I think it's important to note that the Lawyers Committee was literally born of the civil rights movement and the civil rights framework. You and I, in many ways personally, are a product of those opportunities. And that I think most of us would agree that what's happening now is really a wholesale attack on that historic moment. It's not one case. It's not one piece of legislation. In fact, there's a dizzying array of anti-CRT, anti-DEI bill, hundreds targeting racial justice in government, in the education sector, even pushing back on the private sector, which was called in by President Kennedy. Last year alone, 65 bills were introduced to limit DEI in higher education in 25 states and in the US Congress. 8 of them have become law. Being in the midst of it, and I don't know how you carry such a big load, but being in the midst of us, can you help us make meaning? And from where you sit, from where you have this overarching perspective, can you help us make sense of this plethora of attacks?
Yeah, I think we're having this conversation in a very timely moment because we're celebrating 60 years since the passage of the Civil Rights Act, a law that was so instrumental in, as you said, breaking down barriers for Black communities and other communities of color that experienced intense segregation, exclusion, disenfranchisement. And we know that the strong enforcement of the Civil Rights Act continues to be so critically important today, especially in light of all of these attacks. As you mentioned, the attacks that we are seeing after the SFFA ruling are not limited to higher education. They have spanned way beyond higher education, probably much more than we even imagined before the ruling came down. And we're seeing attacks in multiple sectors, including in the charitable giving space with the ongoing lawsuit against the Fearless Fund, in the employment space with multiple lawsuits being filed against programs that seek to advance opportunity through fellowships and internships. We're seeing attacks in the federal contracting space, programs designed to advance opportunity for disadvantaged business owners. And I think we're going to continue seeing attacks. You mentioned the anti-CRT and the anti-DEI laws, and I'll talk about those in a moment. But before I get to that, I wanted to just briefly note that while there have been a lot of lawsuits filed in the wake of the SFFA ruling in a variety of sectors, that they're really having mixed success, right? We tend to hear a lot about the negative rulings, such as the recent 11th Circuit ruling in the Fearless Fund case, where the 11th Circuit, consisting of 3 judges, 2 Trump appointee judges, who upheld the injunction while the litigation will move forward. We hear a lot about the negative rulings, right? But we don't often hear about the cases that are being tossed out. And there have been several cases that have been tossed out for standing reasons, basically, you know, because the plaintiffs are not able to show that they were actually injured. And in a lot of cases, our opponents are not having success in the courts. And so I think it's really important to take note of that. And that is why it is so important for us to keep fighting when these lawsuits are filed. Oftentimes they are lawsuits without merit. So when these lawsuits are filed, we need to keep a close eye on them and fight vigorously to ensure that justice prevails. With respect to the anti-CRT, the anti-DEI laws, you're right. Several states have passed them, and at our organization, we're very lucky to have a deep expertise in the education space. Our team is led by my colleague, David Hinojosa, who argued before the Supreme Court in the UNC Harvard SFFA case. He argued on behalf of a multiracial coalition of students and alumni at UNC. And the team has deep, deep expertise on these issues. They continue to be engaged in impact litigation to ensure inclusive educational environments for Black students and students of color. And recently, they've been engaged in 2 fights in the courts, one challenging the Oklahoma anti-CRT law, and then also in Arkansas, challenging their LEARNS Act or their anti-CRT bill. And in both cases, they've gotten partial preliminary injunctions that have limited the scope of the law and has provided clarity to teachers who are teaching students on issues surrounding African-American history. So we are engaged in these fights on a day-to-day basis, and we will continue to push back, not just, you know, through our resources, but including with the resources of our pro bono partners, and also with partners like GARE and your organization, Kathy.
Thank you. So I thank you so much for noting that when there is a loss for racial justice, it gets an enormous amount of attention. When we hold ground, when we win, crickets.
Crickets.
Your organization has had several key wins, and you get crickets. And thank you for raising that, because this is not just a legal battle. In fact, the fact that most of the cases are lost demonstrate to us that it's not really a legal battle. It's about the story.
Right.
It's about the story we tell, and there's this enormous effort to tell a story that racial justice can't win, to bring us back more than 60 or 70, perhaps 100 years into a social environment that was harmful for so many people.
Yeah.
In February, Arizona State Senator Anthony Curran likened some of the DEI initiatives, equated them to support for Black Lives Matters, for LGBTQ rights. So it's clearly not about these programs, right? It's an attack on racial justice writ large. It's an attack on the LGBTQ movement. How broad do you think the target is based on what you're seeing? How deep and broad is this agenda?
Yeah, I think the agenda is quite broad. And we talked about the Fearless Fund case just a few moments ago. What's ironic, deeply ironic, is that the law that our opponents are using to bring these claims is Section 1981, which is our oldest civil rights law. And it was a law that was passed during the Reconstruction era to give full rights to newly freed Black citizens. And it's a law that was passed with race-conscious intent, right? It was meant to provide full rights to eliminate discrimination in contracting on the basis of race and other protected categories. And so the fact that they're willing to use that particular law to pull down these programs tells you a lot. And as you said, I think that their target is very broad. It's very broad in terms of the types of programs that they're trying to attack. For example, there's a guaranteed income program in California, the Abundant Birth Health Project, that is aimed to provide targeted interventions to address the disproportionate rate of maternal mortality rates faced by Black women and Asian Pacific women, and they have been sued. These are cases that is a program that seeks to improve mortality rates. We're talking about life and death, and they're going after that program. And the evidence is so clear that Black women suffer much higher mortality rates than white women when it comes to pregnancy. And the fact that they're even going after programs like that, I think, is quite shocking to the conscience. So, but it's much deeper than that, right? And you alluded to this. I think that the goal here is to deter, it's to instill fear, it's to roll back progress that has been made, and it's to stifle any conversation of systemic racism and discrimination, which we know continues to be so pervasive in our society. And so I think that their goals are quite broad, and we need to just continue going into this fight very clear-eyed about what their goals are. And as you said, to not only be focused on impact litigation, policy advocacy, but to also be out there trying to change the narrative, to make it clear that we need to be talking about systemic racism and targeted interventions, that they continue to play a really significant role in the work that we do, and that we will not be pushed back into not talking about our history, and that it's really important for students to learn the full history of our country, because that is important for all students. It's important for our country. When we've had these conversations in the past, Kathy, you always go back to, this is about ensuring we have a strong democracy, right? You cannot have a strong democracy without having a multiracial, inclusive democracy. And so this is what this is about. These are attacks on democracy, and we will continue to fight back.
In fact, the civil rights movement was probably one of the most successful pro-democracy movement in history. And what you're raising now, let's just go back to that shocking fact. New mothers are dying at higher rates. Infants are left orphaned, half orphaned, because of racism. And there are people who neither want us to talk about it when we're talking about policies and social problems, nor do anything about it. They're literally taking the position that these women, you should just let them die. So we need to understand the depth of this. And you mentioned the Fearless Fund and that case and their Strivers Grant program. It is reaching into every area of life. As you said, education, economic opportunity, employment. The Fearless Fund set up the program that was challenged because less than 1% of venture capital goes to Black women, although Black women disproportionately found businesses. So I read that they're the most founding and the least funded. They're both underrepresented and underestimated. So it became the mission of the Fearless Fund to rectify this injustice around opportunity, because you cannot have a thriving, healthy democracy if there isn't a fair, actual access to real opportunity for everyone. How can an effort like that, how can a mission like that be advanced today? I know that you said mostly they're losing. There are a million ways to move forward. How would an organization like that move forward in light of the current environment and the case that was just decided?
Yeah, it's a great question and one that we're getting a lot these days. I think it's important to note first that the Fearless one, they actually won at the district court level. They prevailed on their First Amendment defense. And then when the case got appealed to the 11th Circuit disagreed and found that the Fearless Fund did not have a First Amendment right to pursue their mission-driven work of investing specifically in businesses owned by Black women who, as you said, are so severely underfunded. The case hinges on what is a contract, right? So the case was brought under 1981, Section 1981, which, as I said, prohibits discrimination in contracting on the basis of race and other protected categories. And the courts here so far have found that the Strivers program, the contest, is a contract or it's likely to be found that it is a contract. This is a case that is still very early in the litigation. It's still at the preliminary injunction phase. So the case is going to be remanded back to the district court to be fully heard on the merits. But what the 11th Circuit found was that it is likely that the court will find that there is a contract here because there was an exchange of promises, right? In exchange for the receipt of the money, the Black women business owners that gave up their intellectual property rights to the Fearless Fund. And so typically what these cases hinge on is whether there was an exchange of promises that result in a binding contract. And the truth is that a lot of the cases that have been brought recently challenging charitable giving programs, they're programs that target businesses. And I think that for philanthropy, there's a lot of ways to structure grants so that they don't rise to the level of a contract, right? And I'm not a tax law expert, but I do know that grant makers have a lot of flexibility in how to structure their programs and ways to continue advancing racial equity. And so one thing that, we've been saying a lot as we've been talking about these issues is that now is a moment to really lean into creativity, to think about creative solutions, to make your programs legally defensible, to make them resilient, and to allow you to continue pursuing your goals. It's not a time to retrench, to fold, because if we do that, as you and I say, you're doing the opponent's work for them, right? And if anything, this is a time to increase investments in Black communities and organizations that are really doing impactful work in Black communities and other communities of color. It's not a time to pull back. So we've been encouraging organizations to remain steadfast. The Fearless Fund litigation will be ongoing and we will see where it ultimately lands. But at the end of the day, there's a lot that philanthropic organizations can do to continue investing in Black communities and other communities of color.
And it sounds to me that what you're saying is there's a lot everyone can do, right? Again, back to the birth of your organization, President Johnson had said, we need to all be in, private sector, public interest, government. And this is an all-in moment. It's a historic moment. If the civil rights freedom fighters didn't stop in the face of even more terror and attacks and threats than we have now, then what excuse do we have? As you said, we don't want to do our opposition's work for us. They want us to stop talking about race because when we have the conversation, people of good conscience respond and we start solving problems together. Problems that for some, they prefer to leave unsolved. But as we both noted, it's democracy that's at stake. So I just want to thank you for your work. Thank you for the tireless advocacy. Civil rights lawyers have always played a crucial role in racial justice. And we can't thank you enough for being one of the ones on the forefront.
Thank you so much, Kathy. It's such a pleasure to be in this fight with you. and really proud of the work that we're doing together. It's a real joy to be able to serve our communities together. And just thank you for your ongoing partnership. Really appreciate it.